What's up, everybody? Grand Rising. This is Arrogant Prepper and Kiki, and we're going to talk about executors and administrators. This is a document coming out of Corpus Juris Secundum, and I just read through it a little bit, and it's not a long document, but there were a few parts that I highlighted in yellow here that it just kind of turns into a lot of word magic, and maybe Kiki can give us some context and just kind of answer some questions. But should I go ahead and read this and then we can kind of talk about it as I go through it, or how do you want to do this?
Let's do it that way, however you want to do it. Hi, everyone, by the way.
All right, let's do it. Let me make this
Okay.
full screen, and I don't think these can be seen, but move those out of the way. All right, so from the top, my hand. All right, executors and administrators, circumstances. Subsection 16, judicial requisites, fact of death. So we're talking about requirements for facts to prove a death, I would assume that means.
So,
Research,
so what basically what it means is that if they are to take jurisdiction over anything, be it a court case, be it you going into Social Security Administration office or any office for that matter, they would need to make sure that they have jurisdiction, and their jurisdiction in order to administer or execute is going to be fact of death. Which death we're going to determine.
excellent. All right, research reference West's key number digest, executors and administrators. Do you want to explain this? What this is? Is this just a reference that they're talking about?
Yeah, it's just a source that's cited, West Key
Okay.
Number Digest. So it's probably coming out of a book or some type of digest circulation or something like that from the older days.
Okay.
Yeah.
Great. Okay. The death of the person on whose estate administration is sought is a jurisdictional requisite, which makes sense. You can't administer someone's estate if they're not dead.
Yep.
That would just be taking their stuff. So while the presumption of death arising from absence may be present, may present a prima facie case sufficient to warrant a grant of administration, if it is subsequently develops that such person is in fact alive, the administration is void, which
Yeah.
is what we're doing with our name changes. Uh,
Right. So just to play with that a little bit, basically what it's saying is yeah, okay, well, we can take jurisdiction if you're dead. So we can administer upon your name, upon your property, upon your estate, and estates is just a group of rights and liabilities combined. If you're dead, so if a finding of fact has been made that you're dead, then we can go ahead, take hold, trespass, buy, sell, and trade, all of it, everything. Get involved in your property because it would be considered public because you're dead.
Now, is it right that this came like this Cesta QV system was created having to do with like the plagues, the fires in London, and basically there was a bunch of dead people, people missing, and they needed a system where the government could administer these estates until people kind of came back and said, "Hey, I'm alive. I'm claiming my stuff." Does that align with what kind of about the way this was created, this system?
Well, actually, that's the cover story. Um,
Okay.
it's actually from what I've been able to find so far under performance bonds, and you can pinpoint this in Wikipedia under performance bonds, is that this is an old slavery system that was first recorded in 2750 BC.
Mm.
And so, who did the enslavement? I guess we can sit there and we can have another Zoom about that, but it is a system of slavery, physical slavery, labor slavery, dynasty, family, lineal, spiritual, all of that stuff. Um, in its entirety, it's a slavery system. And
Mm.
so for those who, back in the day that we know of, at least in our history books and our academics growing up, um, the books that we were given, we were told that the slaves were illiterate, they weren't allowed to read, they weren't allowed to write. And that's actually the case, because if they were able to read the encryption and write the encryption, then there would be no slavery.
Mm.
And so again, this is an ancient game that's been going on for a very long time. And if you're unable to read or write your way out of your own slavery contracts, then you deserve to be enslaved, and that's how it's viewed.
Right, right. Let ye who is ignorant be ignorant.
Yeah.
All right, let's keep moving on. Okay, it's absolutely essential to jurisdiction of administration. Do I read this? I think so.
No.
No? Okay. It is absolutely essential to jurisdiction of the administration of an estate that the person on whose estate such administration is granted is dead. A living
Yeah.
person, yeah, a living person has no estate subject to probate, and there is no vested right of inheritance in an estate of a living person. Any administration of the estate of a living person is void.
Oh yeah.
Yeah.
So this is where it starts to get good. And this is where we've seen over the years, people coming out, oh, is an affidavit of living man, affidavit of living woman. And, hey, more power to you if you want to try to come up with these methods that will help determine whether you're alive or not. But unfortunately, that's not the requirement. Okay.
Right.
And so in order to prove life, you have to go to the court of proof, and you have to provide evidence. And that evidence is evidence of an active bond. Okay. Would you mind just moving the screen over just to the left, just so I could,
Yeah.
yeah, thank you. Perfect. So it is absolutely essential to the jurisdiction of administration of an estate that the person on whose estate such administration is granted is dead.
Mm.
So any public court proceeding is a public administrative proceeding. Okay. Social Security has its Social Security Administration. That's really what their name is. And so they are running the new Sedike or Setwikuvi Trust right now. And if you were to go into the Social Security Freedom of Information Act website and request your numinant record, of course it has to be a certified copy. You will find that you have to click a check mark where it says that it's for the deceased's record. Okay. And when you receive that back, it's going to be with your name, the original application certified, and a document with two grommets at the top and a red ribbon running down like a vampire bite.
Mm-hmm.
And it's basically going to say, yeah, we have custody of these records that are established. What does that mean? That means that at some point, you were considered dead in their system, and they are the ones who are administering moving forward. So they are now saying that they have jurisdiction because someone failed to do something, although they never really expound on what it is. And that allows them to administer. Now, in the Social Security Palms manual, it also says that we're the ones who did it, and we're the only ones that can undo it. And when they undo it by giving them certified evidence or a court order, typically is what they want, showing that the name is active, this is where the second part of that comes in, where it says a living person has no estate subject to probate, and there is no vested rights of an inheritance in the estate of a living person. Okay. So in other words, there's no trust. You remember Beetlejuice when they said, never trust a living? That's exactly what it is. And the trust breaks open because the original heir comes back to claim everything as proven that they're alive. And so this is why they say any administration on the estate of a living person is void. It has no force and effect in law. That's what void means.
Mm. Lovely.
It's nice.
Lovely. All right,
Yeah.
let's keep going. While the presumption of death arising from a person's absence who is unheard from for a considerable length of time may present a prima facie case sufficient to warrant a grant of administration on his or her estate, the presumption does not take the case out of the operation of the general rule of the subject, and if it is made to appear that the person is in fact alive at the time such administration has been granted, the administration is absolutely void.
Yeah,
Yeah.
more of the same. More of
Yeah,
the
okay.
same. It's
I was
just
just
a
gonna say that's just
presumption.
re-saying the same thing. Okay.
It is. It's a presumption. So you have a presumption and you have a fact. Okay. And so far, we're just looking at a whole bunch of presumptions. We're presuming that you're dead. We're presuming that this, we're presuming that that, because there's no facts have been presented. The jurisdictional requisite is a fact of death. And right now, we're just looking at presumptions, presumption of death, because if it's proved to be otherwise, it's void. So there is no fact. It's all presumption.
Got it. Okay. Although there is authority to the contrary, it has been held that payment to an administrator of an absentee who is not in fact dead is no defense against the absentee or his or her legal representative, nor are costs and disbursements incurred by such administrator a legal charge against the absentee or his or her property. And I think I've read that 3 times, and I probably would have to read it again to comprehend it. So if you can shed some light, that'd be great.
Okay, so it's basically saying that if there's okay, so there's a payment somewhere. Okay, someone somewhere made a payment to an administrator. Okay,
Mm-hmm.
now I know that in this specific case, when we start dealing with administrators and executors and rights and things like that, a payment is really a transfer. Okay, it's a transfer of property. And so what this is telling me is it looks like the name of the property was transferred from one jurisdiction to another. Okay. So it's basically saying, although there is authority to the contrary, which means that, hold on a second, something is opposing this force, it has been held that a payment to an administrator of an absentee. Okay. So someone paid an administrator the property of someone who wasn't there, who is not in
Mm.
fact dead. Okay, remember, we're
Mm-hmm.
looking for facts. So who is not in fact dead could be an attorney, in fact, that pops up, right?
Mm-hmm.
It's no defense against the absentee. So if that guy shows up and says, wait a second, you took my property, and the other guy's, but wait a minute, I took your property and I paid it over to them. And so now I get to get this and I get to get that, and spoils of war, and you weren't here, and you're prisoner of war missing in action, POW, MIA, black flags, pirate flags hanging outside the post office,
Mm-hmm.
right? It doesn't matter. You have to give me my property back. I don't care what you thought you did. Okay?
Lovely.
Yeah.
Mm-hmm. Okay. That helps.
Yeah.
Okay. Let's keep going. Where the administrator has paid debts of the absentee, however, he or she is subrogated, and I had to look that word up,
Oh, yeah, it's a good one.
which means, there you go,
Stepping in the shoes once you made a payment.
to put in the place of another is what
Yeah.
the Merriam-Webster says. Okay. He or she is put in the place of another to the rights of the creditors whom he or she has paid. On the other hand, it has been considered that the invalidity of the administration does not relate back, but that it is invalid only from the time when the presumption of death is rebutted. Okay. Can you explain that? I think I know what you just said, but
This is beautiful because here's the deal. When we're talking about, okay, so, well, can we make it smaller so I can see
yeah.
both? Because it looks like two worlds are going on.
You want to see both pages or
Yeah. Yeah.
like
Oh, it's
that?
all the way up there. Okay, that's all right.
We can do like that.
Okay. Just go up just a little bit. Let me see here. Okay, subrogation. Subrogation is awesome. Subrogation basically means, listen, if I came in and I made the payment, now I get to act as the person who made the payment, which means if I bought it, I get to control it.
Mm,
Okay. So if I okay, let's look at it like this, right? You go out somewhere and you go to, I don't know, Idaho or something, and you know, I need a car, so I'm gonna go over to Avis, rent a car. Okay.
mm-hmm.
I'm gonna rent this car. I'm gonna use it. I'm gonna use this car for a week. Okay. You're gonna use their car. You're gonna drive around in their car. You're gonna maintain their car. You're gonna put gas in their car. You're gonna make sure it doesn't get scratched up, banged up. But they're the ones who actually bought the car. Okay. So they can come back and control that car when the contract is up. And even with the contract, there are still stipulations, right?
Mm-hmm. Mm-hmm.
So if anything happens, they can come in and step in and say, go get my car from this guy. All right. So that's not the best example of subrogation, but it pretty much means, look, they paid for it, okay? They get to control it, and you get to use it. All
Mm-hmm.
right. Now, on the other hand, at the bottom, it has been considered. So there's consideration here, okay? That the invalidity of the administration does not relate back, but it is invalid only from the time when the presumption of death is rebutted. So hold on a second. Here we go. I might have came in and got my name changed and brought to Social Security at I don't know, 2016. But the name change and the bond that's connected to it happened when I was born on January 1st of 2000 or 1966, let's just say. Okay.
Mm-hmm. Mm-hmm.
So the presumption of death gets to go back and rebut all the way back from when I was born, because that's what the document says. So you have to give me everything back.
Okay. Yeah, that's kind of what
Okay.
I thought it meant, which is great.
Yeah, that's what it means.
It's good for us. Okay, let's keep going. That's awesome.
Yeah. Mhm.
Moreover, the objection to administration of the estate of one presumed to be dead is obviated by a statute authorizing the courts to provide for administration of such an estate under reasonable regulations and adequate protection of the property rights of the absentee if he or she should turn out to be alive. And I'm going to look up obviated, which
Yeah, that looks like a caveat for trespass.
is to anticipate and prevent or eliminate by a statute authorizing the courts to provide for administration. Okay. Do you want to kind of summarize that?
Okay, so let's say the objection to administration of the estate of one presumed to be dead. So hold on a second. You can't come in here and administer this estate and so on and so forth. And they're saying, wait a minute, yes, we can. We have
Mm,
a statute that authorizes the courts to provide for administration of such an estate if it's reasonable and adequate, and we're protecting the property rights while you're not here.
right. We're just, come on, doing you a favor.
Yeah, that's exactly what it's a trespass. It's a trespass loophole. Well, you weren't here this whole time, and where have you been this whole time? And we've gone through all of this craziness to protect your property, and look how you're talking to us. And in a way, in a warped, twisted way, they're kind of right.
Right? Yeah, I was kind of thinking that, like, well, what are you supposed to do if an estate is just sitting there and not being, it's just land that you're supposed to let just sit there? Like,
Yeah,
it
I mean,
has to, got to do
we
something with
can't
it,
be angry. We can't be angry with the administrators over everything, right? Because
right?
I mean, yes, of course, the information that we're finding out now has been hidden from us for, almost 3,000 years. So that's not cool, but we have it now, right?
Mm-hmm.
And and so, when we come in with the evidence, listen, I'm alive. I appreciate you guys doing everything you did but moving forward, from this point moving forward, I don't need your administration anymore. Okay. And the reason why I don't need your administration anymore is when I show up with that name order, I have the power to execute, right? So if we go back up to the tippity top of this just really quickly,
All the
all
way.
the way up to the top, all the way. Keep going.
That's it. We're there.
That's it. So right at the top left is the caption. It's letting you know where we are and what we're doing. Executors and administrators. If you are being administered against, that's because you have not come up with the name order showing that you have proof of life. When you do have the name order, now you have the power to execute. You're the executor of that estate. And the name change order gives you the power to also be beneficially interested in it. Does that make sense?
Yes.
So now you're the beneficiary and the executor instead of the dead victim that they're dragging your corpse around, and you're paying for something.
The Walking Dead, Civiliter
That's it.
Mortuus, and
That's
that's
it.
we'll put
I'm
the
gonna
graph we'll put the graphic up right now.
That's it.
Okay, let's finish. We're almost done. Jurisdictional requisites, existence of assets, research
Oh yeah.
reference. Okay, to render administration on a decedent's estate proper. I love how they put that little proper in there.
Oh yeah.
Assets within the jurisdiction are ordinarily necessary, at least where
Yep.
administration is sought elsewhere than in the domicile of the decedent.
Okay,
So
this is awesome.
yeah.
It looks like a bunch of gibberish, but this is awesome because remember, we're talking about fork tongue encrypted languages here, okay? To render administration on a decedent's estate proper. So decedent is the one who is dying. Okay, that's a fictitious name. It's actually an office. It's an official position. Okay, the one who is dying, the dead guy.
Mm.
On his estate proper. Okay, so assets. Assets is going to be all the rights, duties, liabilities, profits, proceeds, rents, easements, mineral rights, anything that can generate some form of I want to say income, not the way that we think income is, because none of us actually have income. We're just trading labor for debt. So income is another definition that would be interesting if you look it up. But within the jurisdiction are ordinarily necessary. That combination word right there, ordinarily necessary.
Yeah.
What we think that is absolutely not what we think it is. The necessary party is going to be what you guys understand to be the transmitting utility. I think that's what you guys are calling it.
Hmm.
Okay, I don't say you guys, but you know what I mean.
Yeah.
That's the word. That's the buzzword that's going around for it. It's the first name, middle initial, last name, all capital letter. That's Mr. Necessary. Okay.
Mm.
And ordinary is the same thing as common, which is the same thing as a plantation, which is the same thing as slave. So ordinarily necessary is the commoner fictitious name, at least where administration is sought. Yes, because you have to be dead to use Mr. Necessary in a slave plantation capacity. Okay. And where it's sought elsewhere than in a domicile of the decedent. So the domicile is different. The domicile is different than the administration. So there was a document, I'll have to send it to you. I was chasing Bobby around for it. It goes into the changing of the domicile. Actually, it should be in the you should be in the group, you should be able to find it. And what that essentially is it's where the name goes once you change it. Okay. It's encrypted, but that's what it is. And so it's definitely worth the read. Maybe we can do a video on that one
Yeah.
too.
We could do that one next, maybe.
Yeah. But so this whole chunk right here is basically saying, yeah, listen, if you want us to do everything on the proper form, assets within the jurisdiction are ordinarily necessary, which means you have to be dead, at least where administration is sought elsewhere. So let's say, for instance, so here's an example. We were out in the Midwest and I'm from the East Coast and I have all my decrees and documentation on me. And I got pulled over and he says, whoa, I can't verify you in my system. You're absolutely right. You can't because I'm not there.
Right.
Okay. And the only thing he wanted he says, I need insurance for either you or your automobile. Okay. Not vehicle, not this, not that. You can do whatever you want. And so why? Because they were seeking to do administration elsewhere other than the domicile. Okay.
Mm.
But he didn't have access to it. He's locked out of it. Why? Because you're trying to administer on something and you're talking to the executor. Okay.
Which they can't
No,
do when you're
no, because
already.
yep. Because they begin to act as what's called an executor de son tort. That would be
Mhm.
interesting to look up.
I've got that here. Hang on.
Yeah.
It's in my diction maps. Oh, tapping into the good stuff here. Executor.
Nice. Look how organized you are.
Oh, where'd it go? There it goes. So here's Executor Descent Tort from
Oh
Blacks
yeah.
and Bovier's. And hang on, my dog's scratching at
Oh
my
yeah.
door. Come on, doggy. Come on. Up. Oh, good boy. All right. Of his own wrong. Okay.
Yep. You can't execute. Sorry. You're not authorized. You don't have a court order to authorize that
Without
authorizes
legal
you to execute.
authority, takes on the responsibility to act as an executor or administrator of a decedent's property. Yeah, I like that one.
Yeah.
All right, let's close that. All
Yeah.
right, and we're almost done. Last bit. Okay. It has been stated that in order to render administration on the estate of the decedent's proper, the decedent's again that proper, the decedent must have died possessed of some assets or property. This cannot be held to be established beyond dispute where administration is sought in the domicile of the decedent, although there is no doubt that assets within the jurisdiction are ordinarily necessary when administration is sought elsewhere than in the domicile. Where property relied on to establish jurisdiction has come into an absentee's beneficial ownership during his or her absence, jurisdiction must fail unless the applicant establishes the absentee's acquisition of the beneficial ownership prior to his or her death. Okay.
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 So, where property relied on to establish jurisdiction has come into an absentee's beneficial ownership. Let's stop there. Absentee means absent from the record. Okay. We haven't put our records in. We're moving around, but we haven't put them in, but we're not necessarily dead. We're not necessarily alive. We're kind of in the middle. Okay. Now, beneficial ownership basically means that you're the beneficiary of this trust property, even though you haven't made it home yet. Okay, to put in your documentation. Jurisdiction must fail. They basically they can't take jurisdiction over you being dead because the absentee just turned to the beneficiary and is on his way home. Leave him alone. Okay, leave him alone. He's on his way home. Leave him be. All right. Unless the applicant establishes the absentee's acquisition. So that means if someone else can grab the beneficiary position from you, then they can take it prior to his or her death. The beneficial ownership, the absentee, and the beneficial ownership, this guy is the guy he's holding everything, also known as a holder in due course. He's headed somewhere with all these documentation. If someone can intercept and trick him out of his property, trick him out of control prior to his or her execution, then they can get jurisdiction. This is where special appearance comes in. So let's say we're headed home. Let's say you get your name order, you got all your documents ready to go, and you're headed home. Yeah, I'm getting ready to go dump this stuff into this county, and you know what I'm saying, or into this record or whatever, and handle this business and finish it up. It's just like Pinocchio when he was skipping off to school, and here comes that scumbag wolf guy. You know what I'm saying? Hey, what are you doing? You don't want to go to school. Come on over here. Next thing you know, he gets sold into slavery. They turn him into a donkey. A whale eats him, a big mess, right?
Pleasure
It's
Island.
yes, it's the same thing. It's the same thing. And they've got plenty of pitfalls like that for us out here.
Okay.
So if we can get you before you execute while you're carrying everything, then we can get jurisdiction. Now, special appearance comes in like, wait a second, you guys just tricked me out of my stuff while I was heading to school. I got my Apple, I got my books, and here comes this guy. I think his name was Honest John, as a matter of fact, right? And I just realized what happened. Okay, hold on a second. Well, I got my fairy godmother over here with the blue wand, and she's going to smack you upside your head on a special appearance. A special appearance is challenging subject matter jurisdiction to administer. Remember what happens. If we can prove that you don't have the power to administer, your efforts are void.
Right.
Okay? Your efforts are void. So that's what that says. And I thought it was really cool that they put it in there. But again, remember, it's encrypted, but that's what it says. Prior to execution, if we get you, then we can get jurisdiction. Well, hold on a second. You can't get jurisdiction if I come in here as a special appearance and everybody wants an appearance.
That's fantastic. This is why I wanted to go over this with you. There's so much packed in here.
You know?
that
We got
needs
to
to
get
be
that.
unpacked. All right, let's do this last paragraph. We've got 9 minutes left on this Zoom because I don't have a paid account. So let's rock it out.
Yeah.
And this is going to be an awesome video, I think. All right,
Yeah, it is.
the existence of a cause of action for wrongful death
Ooh.
is usually regarded as a sufficient basis for a grant of administration in the jurisdiction where such cause of action has arisen, or where it may be enforced, even though the decedent was a non-resident and has left no other assets in the jurisdiction. The view has been maintained, notwithstanding and contention, that the cause of action has not, and that's the last word on the document.
Okay, so the existence of a cause of action for wrongful death. Okay, that's if you sue them. If you want to go after them at law and sue them for killing you, then you can. There's an existence of a cause of action. Okay, it's usually regarded as a sufficient base for a grant of administration in the jurisdiction. So there's a trick to that. You want to sue us on the public side? Fine. Prove to us that you're alive. If you want to sue us, we're going to take jurisdiction. We're going to administer, and you better hope you make it to the end. Or you can find our equity door, our private equity door that we gave you a piece of chalk for to find with this bond over here. And you can slide off to the right, make a new deal with us, and we'll enforce your private law this way. And hey, no harm, no foul. Remember the girl I told you about? She quitclaimed all the property back. And the judge came down, took off his robe, gave her a salute, and said, "Hey, is it my understanding we give you back everything and you don't sue us?" And she said, "No, not likely." He said, "Fine," and snatched all of her children. She's got a 30-year restraining order against her.
So basically, we have a choice between choosing to war rant against them or choose equity and,
Yep.
stop looking in the past, or we're going to just keep tripping.
Yep. There's always a choice. There's always at every step of the way. Did you
Hmm.
want to do administration? Did you want to do executor? Do you want public? Do you want private? There's always a choice every step of the way.
Amazing. All right, let's
Yeah.
leave it at that. That was fantastic. I'm going to stop this share. Thank you so much for that. That was really amazing.
My
And
pleasure.
we'll just wrap it up there and looking forward to the next one.
Very good. We'll talk soon. Bye. Bye,
Okay.
everyone.
Okay. Bye. Nice. Let me stop that.